Thank you for joining us today. Again, my name is Dan Holmander. I'm here to provide you a webinar on policing strategies for IP. The title is How to Self-Police Your IP Rights. For those who are here today that are existing clients or friends, I welcome you. For those who are new, welcome you as well. And there'll be time reserved at the end of this presentation for any questions that you have. And of course, on our initial slide that you can see, you'll find my email address, and I make myself available to any of you. If you have any follow-up questions, feel free to follow up with me. So let's get started. There are many different forms of IP protection. There are, in relation to that, your strategy for how you protect your IP has a lot to do with the form of IP protection that you're using. The overall goal of today is to explain what IP rights are that are available to you as tools to protect your inventions, your company names, your valuable intellectual property. The next goal will be to identify a process for you to evaluate threat assessment, also in terms of what resources you want to allocate to those threats of IP infringement. And the last section will be dedicated to tactics, both common tactics amongst the four major areas of IP rights, as well as specific tactics related to patents, trademarks, copyrights, and trade secrets. So the first question is, why police your IP rights? For the most part, the government is not going to rescue you from infringement, counterfeiters, and unauthorized uses of your intellectual property rights. Your task, once you've created your rights, is to be your own police force. The main reason why you want to be policing your rights is that 45 to 80% of your company's value lies in its intangible assets, namely intellectual property rights. So these are assets. Like an asset would be a piece of property, a building, a key employee. Any of those assets need to be monitored and maintained and enforced for them to maintain their value to your company. If you were to neglect policing your rights, again, there is not going to be any rescue from the government in terms of helping you in that endeavor. You're going to essentially be devaluing your assets and wasting them away. So it's very important that you police your rights. A lot of people probably, to understand what we mean by self-policing, or in other words, self-governance, I looked at the definition, and basically self-policing or self-governance is a group autonomously managing their own affairs. Or another way of saying a process where individuals or groups, or in this case maybe a company, provide their own discipline and enforce it without outside help. So again, this is a self-service area of law where you are creating your rights, maintaining your rights, and enforcing your rights, whether it be a court or other administrative proceedings or through correspondence. But at the end of the day, the self-policing aspect is inherent throughout all of the intellectual property rights. One exception being if it is a criminal, let's say you have a situation where there's some criminal element involved with counterfeiting. There is a role where the Department of Justice may play a role in terms of prosecuting criminal intellectual property infringement. But for the most part, your average civil infringement is going to be something that you're going to have to do on your own. So what are these IP rights, or we call intellectual property rights? Number one is trademarks. And there are a number of things to talk about. I want to basically outline for you the four major areas, and then we're going to talk specifically about each one and how to create and define what those are. So number one, as I said, is trademarks. A subset of that would be trade dress. Next one is patents. Third one is copyrights. And the fourth is trade secrets. So let's start with patents. Patent is, and you're going to see a common theme here where I highlight the word exclude, is a negative right that allows you to exclude others. Think of exclusivity as in a very special club where only certain people are allowed in. That's what they mean by exclude. There are only a special few people that actually get the benefits of the inventive activity. So the statute is allowing you to exclude or negatively exclude. It doesn't allow you to use or license or anything else. That's not what they're getting. It's not a grant of license from the government for you. It's a common misconception. It's an exclusive right for you to exclude others from making, using, selling, offering for sale, or importing the patented invention. Making is pretty straightforward. Others cannot manufacture your invention. Using is pretty wide. A user could be a person who is a consumer. It could be a distributor. It could be a manufacturer. It could be any one of a very long chain of people delivering goods or services to its final destination. So using has widespread implications. Selling is pretty straightforward. Again, retailers, distributors, manufacturers are all liable if there's patent infringement. And importing, which is a very important aspect of your protection from foreign competitors, importing is also included, importation into the United States. Just as a side note, if you have a U.S. patent, the jurisdiction from which you can actually enforce that is within the United States. So it's making, using, selling, or importing into the United States. This is not going to protect you in Europe. It's not going to protect you in Asia. It's not going to protect you in any other country except the United States and its possessions and territories. The common subject matter that a patent protects is things like software, goods and services, a lot of things that people don't always think about, like websites, business methods, how to operate a business. For instance, a lot of financial institutions have patents on how to open a checking account, how to process a financial transaction, credit card transactions. Financial services industry has a lot of business method patents that are being enforced and redeeming quite a bit of money. Processes, medical devices, anything that is an apparatus has an inherently utilitarian value and is functional is what you're going to use a patent to protect that. The purpose of a patent isn't a destination. A lot of people have the misconception that getting a patent is where they want to go. Getting a patent, or as we call it, the notice symbol of a patent pending or a issued patent notice symbol, which is U.S. patent number, that is not what you want. What you want is an enforceable patent. The difference is very clear. A weak patent or a unenforceable patent is a patent that has a significant amount of limitations in the claim set of that patent. And the claim set is at the very end of a patent and actually describes the metes and bounds of your invention. If that patent has a laundry list of 10 or more elements, there's a very good chance that the only person that's infringing that patent is you. Thereby, that patent has very weak or very non-existent enforceability, and also in terms of its licensing and other things is very undesirable. What you're looking to do is get a high-quality patent or a strong patent. And a strong patent in the same scenario would be a patent that has few limitations, and that it will then cast a wide net to a large group of infringers if they were to come close to your invention. And that halo effect over that patent is what really drives revenues, protection of your market share, and any litigation. We call that the halo effect, I call it a deterrent effect. So the idea is that if people see a high quality patent with few limitations in the claim, they're going to be inhibited or deterred from infringing on your patent. If you have a very low quality patent and it has a lot of limitations, then you're going to discourage very few people, and more often than not, you're going to have a very difficult time preventing design arounds. So having a strong patent is really essential to self-policing your patent rights. Just a comment also on the notice symbols. When you see patent pending, there's no enforceability in that phrase. Patent pending has a very distinct meaning, but it's commonly misused. A patent pending is an actual live patent application that is being prosecuted before the United States Patent Office. Oftentimes people file let's say for instance, a provisional application which is only good for 12 months. It expires in 13 months and they have not removed the notice symbol patent pending. So it requires a bit of investigation when someone says they have patent pending. When you see an issued patent number, you should be able to look that patent up in the U.S. Patent Office and be able to identify and review and analyze the strength of that patent. So I want to make it very clear that there is a deterrent effect with saying patent pending, but the strongest form of protection is an issued utility patent, and if that's not available, a design patent. And the last note on patents, and again, this is not intended to be an exhaustive overview of everything about patents. We're just getting out some of the basics so that we can tie this into policing tactics. Is that for a specific oftentimes with patent infringement, when you get to a damages phase in a court trial, you're going to be looking at different metrics for determining damages. One would be a reasonable royalty, which could be a different range depending on the product and the industry. Sometimes it's not enough to deter people, unfortunately. When you have design patents, and even though design patents are a ornamental patent which covers the surface orientation or the surface look of typically a good, but it also could be a website and other things, that actually there's a special form of protection. We call it design patent infringement. We would be able to recover infringers' total profits. So the idea is it's not a reasonable royalty. If we're to prove patent infringement, we're eligible to receive all the profits that the infringer made on that particular device. I think the underlying policy reason is that design patents are a lot easier to move around. And if you weren't concerned enough to actually do that, then you're going to get penalized greater by having to disgorge any profits that you made in that product. So it's an important tool to recognize, and we'll tie that into some of our tactics later on. Let's talk about copyrights. Again, we're going to highlight the word exclude. These are exclusive rights. A copyright excludes others from reproducing, distributing, performing, displaying, or preparing a derivative work of the original work of authorship fixed in a tangible medium of expression. In other words, in order to have a copyright, you have to have an original work of authorship. The original work of authorship should be documented. You should have evidence that you were the creator of that original work. And fixed in a tangible medium of expression could be a piece of paper, could be a digital file, could be a website, but it has to be tangible. It can't be a thought or an abstract concept in your mind. And then in return for having that copyright, under U.S. copyright law, once you've created the original work, you now have a copyright. You're not required, there's nothing necessary to do anything further. However, it's not always enough. We oftentimes recommend that you provide a notice symbol. The notice symbol, which is C in the circle, will give, again, another strong deterrent effect to others to identify that you are the original work of that author. You're the original author of that work and that you are the one that owns that copyright. If someone were to see the C in the circle and not investigate it, it'd be very difficult for them to claim a defense of innocent infringement. So to use the notice symbol judiciously and in the proper location, in a prominent location, is very important in terms of deterring others from infringing on your rights. As a copyright owner, you have a bundle of sticks. Essentially, you're able to reproduce, distribute, perform, display, or prepare derivative works. And it's more far-reaching than that. But at the end of the day, what you really want to do is understand that you own all of those different rights and that they can be parsed. You can actually have somebody who just reproduces your copyright. You can have someone who just distributes it. And so therefore, you should be thinking about controlling all 6 of those bundle of sticks. Subject matter of copyright is actually the most difficult thing to define. Unlike the other 3 major areas of IP rights, copyrights actually have a scattered history of a variety of exceptions of what will and will not be the subject matter of a copyright. Traditionally, anything that was inherently functional is protected by a patent and not by a copyright. However, there are some exceptions to that. So some subject matter examples would be software, websites, jewelry, videos, photos. Then you get into ship hulls and semiconductor chips. There are specific laws that are actually making or creating these exceptions that say, well, semiconductor chips are inherently functional. However, the topography of that chip will be protected. So you're not always exactly clear as to what will be protected or not under copyright. And if you have a good or service and you're looking to see if you can protect it, you oftentimes want to look at some of those exceptions. Software isn't, one note on software, you're protecting the underlying source code and not the actual pseudocode. So that's an important thing to remember. Jewelry is probably a good example of how far copyright law will extend itself. Jewelry is essentially has some utilitarian value, but for the most part, it's overridingly a artistic expression and has very little functionality to it. And that's where you start walking the line. A website, and this is a very popular thing to do, is to protect your website, the text and images, with a copyright. Oftentimes you'll see on an Amazon site or eBay, at the very bottom will say all rights reserved, see in the circle, no symbol. And essentially what they're saying is anything on this page is owned by Amazon or eBay. That's a very important thing to do. Again, it's called deterrent effect. And that's a proper place to usually apply the no symbol on a website. Another important thing to know about copyrights, and will tie in later into our enforcement, is statutory damages and attorney's fees. The caveat being that if you were to register, okay, there's such things called unregistered copyrights and registered copyrights. Unregistered copyrights are what you're given upon the creation of the original work of authorship in a tangible medium of expression. To register your copyright requires a ministerial act of filing an application with the U.S. Copyright Office. In the absence of a registration, you are not eligible to receive statutory damages as a right and attorney's fees. If you are to register your copyright with the federal government, and the fee is oftentimes anywhere between $35 to $55, you are eligible to receive statutory damages and attorney's fees so long as it was filed within 90 days of the original publication. Statutory damages can range, once copyright infringement is proven, from $750 per infraction, and if it's willful, all the way to $150,000 per infraction. Even if that particular copyright has absolutely no economic value, and it's and even if that's proven to be true, if someone is to copyright, someone to infringe on your copyright, you're still eligible for statutory damages. So it's a very powerful tool. We'll talk about how we use that at a later time. Trademarks. Again, we're emphasizing the word exclude. These are exclusive rights, excluding others from using the trademark, or in this case, a trademark is defined as an indicia affixed to goods or services used in connection with the sale to identify the source of the goods or services. So again, it's a negative right to stop others from using your indicia. What's indicia? It could be a variety of things. It could be a logo, it could be a word, it could be a symbol, it could be a sound. Any of those things could be considered indicia. If that indicia is affixed to your goods and services, so physically connected to. For goods, it's pretty straightforward. If you have a good, you can put it on a hang tag, you put it in the bag, you could put it on the packaging, you could put it in the manual or anywhere prominent. For services, it's a little bit more difficult, but oftentimes, if you were to provide that on a website, brochure, marketing materials, that's where you would want to affix what we call a service mark. And it's used in connection with the sale, so it's used in commerce. If you have a trademark, you actually are using it in commerce where cash is exchanged hands. Oftentimes, people will assert that they have a trademark, but they've never actually used it. So you have to use it in order to actually have protection. And then you're identifying the source of goods and services. So the actual underlying person or company is associated with those goods and services. But again, the key here is that the strength of that trademark is going to provide you with, again, a deterrent effect. So the destination, again, here is not just to receive or to say to others, I have a trademark, or even better, that you have a registered trademark. The goal is that you're using a trademark that has enforceable value. What's an enforceable trademark? We try to talk about the strength of a trademark being divided into 4 different categories. You have generic trademarks, sugar for sugar, flour for flour, that anyone should be able to use. Those are non-enforceable, and those are not registrable. You have descriptive, white flour, white sugar. The word white, again, is descriptive. Anyone should be able to use that. Then you get into suggestive and into fanciful, where you have no understanding of actually what the underlying good or service is. You just have a suggestion or a thought about what it might be. It takes a mental step. Those are enforceable, and those are registrable marks. And that's where you want to be. And the stronger that your mark is, the better off you are in terms of your enforceability down the line. So what are the examples of some subject matter that we use to protect trademarks? Oftentimes you'll have a trademark on a website. It could be the name of your software, again, a logo. It could be trade dress. Trade dress is a distinctive look. For instance, think of the old Coca-Cola bottle. It has a very iconic look to it. That's called trade dress. It could be a scent, music note, again, goods and company names. There are 3 different kinds of trademarks. You have common law trademarks, which are derived from use in commerce and require no ministerial acts. You have a state trademark. Each state has its own state registration process. And if you receive, for instance, a registration in the state of Rhode Island, you could enforce that registration in the state of Rhode Island only. And obviously that's true for the other states. And then you have a federal registration where you receive protection in all 50 states, possessions, and territories. Ideally, you want federal protection, assuming that you have interstate commerce, then that would be the ideal form of protection. Notice symbols. Again, deterrent effect comes from a variety of things, including educating people what your rights are. So having a TM symbol or an SM symbol for service mark, TM for trademark, would be an indicator that you either have common law rights or possibly that you filed for state or federal rights. R in the circle is a specific meaning that you actually have registered your trademark at the federal level. You received a registration certificate, and that can only be used in that context. Obviously, an R in the circle has a greater deterrent effect than the TM and SM. The TM and SM have been proven to have no enforceable value, whereas the R in the circle has a very distinctive value to it. And lastly, when it comes to trademarks, and we're going to again talk about this later on when we're talking about self-policing your IP rights, is that if you were to register your trademarks and someone to willfully use your mark, then you're eligible for trebling damages and attorney's fees. So tripling the damages and getting attorney's fees is available to you when it's willful. And that would be, again, something that you want to emphasize in your enforcement strategy, which we'll talk about later on. And the last area that we're going to talk about is trade secrets. Every state has a trade secret statute in the United States. Rhode Island has its own. Most of them are based on the Uniform Trade Secrets Act. So let's talk a little bit about what a trade secret is. Trade secret, again, allows you to prohibit or exclude others. Again, the common theme, excluding others, which is the deterrent effect, from acquiring, disclosing, or using your information, which has economic value from not being generally known and is the subject of efforts that are reasonable under the circumstances to maintain its secrecy. So in other words, a trade secret is something that has value because nobody knows about it. It's a secret. And you are required to maintain efforts that are reasonable to maintain secrecy. So you actually can't just say, I have trade secrets and someone misappropriated them. You have to say, I have trade secrets, they have economic value, and I put forth a level of, let's say, compliance, either a compliance program or a series of steps that protected that trade secret, and someone still misappropriated. An example of a trade trade secret would be something like software source code, a formula, like code, a pattern, a compilation, a program, a device, a method, a technique, or a process. So Coke formula is a really important one. There's a vault down in Georgia, Atlanta, Georgia, where only a few people have access to the formula for Coke. That's, I believe there's actually a vault in the side of a mountain somewhere that has this formula. That's the idea of an extreme effort to protect a trade secret. But there are other ways to do it, and even with the confines of a budget. For instance, stamping things with noticeables like confidential, proprietary, or trade secret. What you're doing there is segregating your information and saying this information is confidential or is a trade secret, and that level of effort will be considered reasonable in the circumstances to maintain secrecy. Of course, if you were to label it confidential and leave it on the lunchroom table, that would not be considered sufficient. And at the end, if someone were to willfully misappropriate your trade secrets, they're eligible for exemplary damages, which is 2 times damages, and attorney's fees. And again, we'll talk about how that plays into your policing strategy later on. So that's the overall view of the 4 major bodies of law related to patents, trademarks, copyrights, and trade secrets. So let's get into your process for policing your intellectual property rights. And I want to break this down into 3, I guess, straightforward steps. The real key here is that oftentimes once you get into the process of watching and identifying and learning more about what is going on in the industry with regards to your IP rights, you're going to see a lot of threats. And you're going to see a lot of people who are either infringing or the counterfeiting or the unauthorized distribution, and you're going to have to work within a limited budget. So how do you do that? The first thing you have to remember is you need to do a threat level assessment. Now, you can customize this however you want to. I come up with a score usually 1 to 5 in terms of threat level, 1 being the least level and obviously 5 being the most. If you have a threat level in terms of, let's say, a direct competitor who is using a trademark that's confusingly similar to yours, and they're taking market share from you, especially from a major customer, that would be a 5. If you have a individual who is not sophisticated, has very little money, would not be considered a competitor even if they did, and has probably sold 5 units, that would probably be a 1. And then you have situations that range from along that continuum. But at the end of the day, you need to understand who it is and what the threat level is for it to really be whether you want to take action on it. Because not every infringement or counterfeit item or whatever requires action, and nor could you afford that. So that's step 1. Step 2 is return on your investment. So even if we have a high-level threat, if our return on our investment is very small, that would be a 1. And return on investment can be measured, though, in a variety of different ways, and we don't limit ourselves just to money. Return on your investment in a situation where you have a competitor who's a direct competitor who's using a confusingly similar trademark, and they're taking market share from you, especially a major customer, could be not related to money. It could be just preserving your relationship with that major customer. You might only have the same amount of sales that you had yesterday, but what you want to prevent is from your competitor to get a better relationship with them. So you have a return on your investment. Of course, the straightforward example would be that there's significant damage on the table. Hopefully, though, you are identifying these threats at a very early stage so that the actual profits made by your competitor or the lost profits that you have or the reasonable royalty damage that are available would be fairly small. And if you've waited 10 years, then that would be the case. But for the most part, you may not be able to measure the actual dollar amount in terms of your return on your investment the immediate time, but you're looking at it prospectively and saying, what would be the value of this? What's my return on investment? So when you take step 1 and you step 2, you add the score together, you can then get to the final step, which is, okay, this is a high-level threat and a high-level return on investment, but now what resources or assets will I deploy to counteract this threat? And again, that is going to be determined by, I think, the combination of the threat level and your return on investment. If your cumulative score between your threat level and your return on investment is between 2 and 5, then your resource allocation will be fairly low, or maybe nothing at all. Again, not every infringement, counterfeit, or unauthorized use of your trademark or patent or copyright or trade secret is going to be actionable because of a limited budget. If your cumulative score is between 6 and 10, then your resource allocation ranges probably from medium to high. Those are the times when you're going to say, this is worth it. We have a high-level threat. We have a significant return on our investment, and we're going to receive in return, and we're going to spend a significant amount of our resources allocated for the fiscal year to either defend or attack in order to get that return on our investment. And those situations make sense. Again, there's a number of different ways to calculate this, whether you look at it purely monetarily or based on the marketplace and a variety of different factors, but some level of assessment along this line is necessary before you even decide how actions you're going to take to actually police. What are some of the common tactics across all 4 major IP areas? We call these common tactics for policing infringement. So, number 1 is identify early your infringement or counterfeit activity. The earlier that you identify it, the easier it is to solve, the less resources it's going to require to solve, and you're going to prevent major problems down the line. So identifying. How do you identify? There are a variety of tools that you can use. Obviously, you have your internal employees who are always in competition. They could be a source of detection. You could subscribe to services. There are databases. There are watch services on your industry from a variety of different angles that you can subscribe to. There are business transactions that are happening in the news that you can identify as well. So there are a lot of ways, and it requires some level of watching. A lot of times, watching uh, databases for things like trademark filings or patent publications to really get into those situations earlier than usual. The second step is to educate. So once you uh, create these strong, enforceable, exclusive rights, as we talked specifically about patents and trademarks in particular, you now can start telling the world that you have these strong enforceable rights as a deterrent effect. And how do you do that? There's a variety of different ways. Each one of them has its own particular way, but in a generally speaking, there are notice symbols, which we've talked about, like C in the circle, R in the circle, uh, letters, press releases, virtual marking. All of those things go to informing and educating your industry that you have strong legally protectable rights, and that essentially implies that you're going to use them if necessary. Notify. So when you do identify a competitor, for instance, that they are infringing on your intellectual property rights, it's a good idea to start with usually a cease and desist letter. But I think today, given today's age, those letters tend to be ignored or thrown away, even worse. And you want to be very judicious on who you send the letter to and selective about when you send it to them. Because if you don't act on your letter within a certain reasonable period of time, you've lost that deterrent effect that you've been building up through your education. So sending a letter is important, but be prepared to enforce it if you don't like the answer, which oftentimes is silence. The other way to do it is you can actually file complaints through a variety of different administrative bodies, whether it be through the Uniform Domain Name Resolution proceeding, where you can take others' domain names that infringe on your trademark rights, whether it's through the Trademark Trial Appeal Board, or Patent Trial and Appeal Board, or whether it's filing complaints with Twitter, Facebook, and other social media sites, or e-commerce sites like Amazon or eBay. All of those entities have a complaint process for intellectual property infringement. So it's another way of notifying these third-party infringers is to actually file complaints against them through these administrative bodies or other entities. And then lastly, again, ROI, return on your investment. Understand why you are protecting and policing your intellectual property rights. And understanding what level of resources should be allocated depends on different goals. Each one has a different audience. For instance, investors, particularly ones who are investing in, so let's say, early stage tech companies, are very interested in seeing that there are patents that are strong, and that the chain of title is proper, and that really the only asset of that company is the patent. So you're going to be very careful about making sure that you understand the technical area, and as it migrates to maybe something that's closer to what you're doing. So maybe watching the patent office and identifying publications that similar to yours is important. Maybe attacking other patents in that space is important as well. So that's one audience. Another one could be a partner. You may see somebody who's infringing on your intellectual property rights, and you say, this is an opportunity for us to partner up, to collaboratively work together, and that could be an invitation for that conversation. It could be revenue. You may have some intellectual property rights that are on the shelf that haven't been dusted off in a while, and you've now woken up to the fact that there's a lot of people that might be infringing, and you see an assertion licensing strategy may provide some value to you. And lastly, of course, market share, which is a traditional one, which is about excluding others from competing with you. And the less competition you have, the higher price your goods are, and the more market share that you can grab. So those are some of the common tactics for policing infringement. Let's talk specifically about patents and the tactics used for policing valid patents. And again, I want to emphasize the word valid. We should also say strong. Even though you have a patent, trademark, copyright, or trade secret, and it could be considered valid by the fact that you have received a certificate, every patent can be challenged in terms of its validity through a re-examination process or a court proceeding. So always understand that even though we believe that we have strong enforceable rights, we also will have those infringers may challenge the validity of those patents. So you need to understand how strong your patents are to really identify how you're going to use them. If you have very weak patents, then you may think the deterrent effect is all you're going to get, and by challenging somebody with a weak patent, you may reveal some of the weaknesses in those patents and actually lose the deterrent effect. So be very careful about when you use patents, trademarks, and copyrights, and understand exactly the strength of those. So the first, going back to that rubric that we just started, which is identify, educate, notify, and ROI. And with patents, it's about watching competitors' websites, look at the new product offerings. It's about patent office filings, look at the publications that are coming out regularly, both in the United States and around the world. It's about educating, press releases, virtual marketing notices. So now you don't have to actually fix the notice symbol on a good. You can actually do it on your website. Inventor assignments is very important as well. So knowing that employees come and go and leave, you want to be very careful that you have any inventions are assigned to you that you have, so that you have a clear legal chain of title to those patents when you're asserting them. Notify. Again, beware of declaratory judgment actions. If you send a cease and desist letter, be prepared to defend it and attack. Because if you're sending let's call it a frivolous or very far-reaching letter, you may actually be embroiled in a lawsuit that you didn't intend to. So be very careful about that. How to actually notify someone about patent infringement could be a variety of things. You may want to, again, send them a letter, cease and desist letter directly, or you may want to send it to their best customer. Because going back to our rights about making, using, selling, offering for sale, and importing, any point in the distribution chain can be used and can be sued for patent infringement. So find those pressure points in the distribution chain, and they may be more concerned that they're going to lose either goodwill or a relationship than they are about actually losing money to you in a court proceeding. So use that to your advantage. Return on investment. Again, calculate your potential damages for pursuing patent infringement. If you look at a threat and you say this is going to be very low level in terms of damages, you may say, well, we're not going to put a lot of resources, or we're not going to allocate a lot of resources to that, but we still need to do something. That may open you up for different types of arrangements with how you pursue legal action. Enforcement with patents, at the end of the day, if you can't get action through, we talked about administrative proceedings, through filing complaints with entities like Amazon, whether it be where you filing complaints through border enforcement. At the end of the day, you're going to have to go to federal court, which is exclusive jurisdiction over patent cases. And also be aware of the fact that now there are contingency fee relationships that you can develop that will help you in those cases where there are not a lot of damages, but yet you still want to make sure that the integrity of your inventions are being protected. So those are some of the tactics for policing valid patents. Tactics for policing valid copyrights. Again, identify, watch your competitors' websites. Watching is such an inexpensive way to really getting a lot of value out of your copyrights, because oftentimes detection isn't going to be very apparent to you. With the internet, it's really dramatically changed the landscape on how we find out about infringement activities. So watching, automatic watches, being delivered to your email box or to your attorney's email box every day is a great way of really finding out and deterring people and letting them know that you're watching what they're doing. Copyright Office registrations, again, we talked about the benefits of registering your rights early, providing a public notice to others that you actually own those rights. Educate, again, notice symbols like C in the circle, employee handbooks, and third-party agreements. So you really want to have IP clauses in your employee handbooks to let them know that there's any IP during the course of their employment that you own it, or in a contract or employment agreement. Third-party agreements, you want to make sure, again, if there's any IP, that you identify what you own, and then if there's any co-joint developed IP, that you own that as well, or at least understanding of how it's going to be shared. Notify. Register your copyrights within 90 days of publication. If you do that, you can get statutory damages. When you send a certificate to somebody and that registration was done within 90 days and you say that they were caught, there's infringement, they know that they're going to be liable for statutory damages, $750 to $150,000 per infraction. It's a game changer. If you send them a unregistered copyright notice and say that you think they were copyright infringing, they know that you can't go to court. They know that if you pass 90 days, you can't get statutory damages. And then they know that maybe the value of the actual infringement is very small value, so those letters are probably going to be tossed away in the garbage. So you have to be very careful about when you register your copyrights. Enforcement, again, federal court exclusively, but you can get attorney's fees also if you register your copyrights within 90 days. Tactics for policing valid trademarks. Again, watch services are available for watching filings with the U.S. Trademark Office. Also watch filings around the world. Sometimes people will file in China first or in Europe first and then eventually migrates to the U.S. Domain names are a great way to identify if someone else is using your trademark. You can actually get reports on domain names that are being registered by particular companies, and you can use it as competitive intelligence in terms of identifying also what the trends are in the future. So watching those domain name reports and looking at what they're doing is also going to help you out in predicting if they're going to move in a direction towards a trademark that you own. Educate your customers, distributors and manufacturers, importers, how to use your valid notice symbols, how to use your trademarks, and what you actually own. And that should be in a written agreement. You should have distribution agreements, and they should clearly articulate exactly what it is that you have in terms of your trademarks. And that's true for all of your IP rights. And that way that you have a breach of contract claim as well as trademark infringement if they were to do something otherwise. Notification. Trademarks, I think, particularly lend themselves well if there's any area to cease and desist letters is trademarks. Oftentimes, the infringer could be an innocent infringement or it's a relatively new business and they haven't really had a lot of sales. In those cases, a cease and desist letter actually has quite a bit of effect and will lead to oftentimes negotiated settlements. Unlike the other areas that we spoke about, especially patents, cease and desist letters in this case would probably be very highly recommended. Also talking about registering your rights with search engines like Google and Yahoo and others, preventing certain AdWords from being used, going to Amazon and filing complaints, going to eBay. These are other things that you can do well. These are administrative procedures within entities that you can use. And all those are very effective as well for trademarks. Return on your investment. You really want to prevent dilution or blurring of your trademark, and that leads to market share. So the idea is that you don't want anyone else to have any confusion as to who the source of those goods are. You really want to be very clear-cut. And enforcement. Again, in this case, you can actually go to state or federal court, and it's triple damages if it's willful. The last area of policing your valid trade secrets is policing valid trade secrets. So we talked about identifying, segregate your information and stamp it confidential. That's a very minimum. There's a complete compliance program that you want to put in place if you believe that you have trade secrets that are valid and enforceable. You're going to want to have heavy focus on your employees and your internal processes, making sure there's no leakage, making sure that you have restricted access to information, making sure that you have passwords that are regularly changed, making sure that you have a clear division or firewall between people who are keeping information, not providing all the information about all of your trade secrets to single people but breaking up into pieces. There's a tremendous amount of emphasis there on your employees, because the employees are most likely the ones that are going to misappropriate your trade secrets in the future. Notification, third-party agreements, and handbooks, again, through your employees. The third-party agreements is a lot about working with other companies. If you are engaged in a prospect of building something, of making a product or a service, you want to let them know that you do have trade secrets and that you are going to maintain them as trade secrets, so that they treat them accordingly. Your return on your investment, preventing competitors from attaining competitive advantages. With trade secrets, again, a lot of it's about employees. Sometimes it's hacking or worse than that. But for the most part, you're going to have a lot of leakage through your employees, and you don't want your competitors, who are the future employers or employees, from obtaining those competitive advantages. So you want to make it very clear and emphasizing to your employees regularly over and over again, we have trade secrets, this is what they are, and treat them confidential. And if you don't, we're going to sue you for misappropriation of trade secret. And lastly, again, trade secrets can be enforced in either state or federal court. So to summarize, there's 4 basic things to take away from today's presentation on policing your exclusive IP rights. One is know thy exclusive IP rights. Self-assess continually. What is it that you have? What are the strength of those rights are? How far-reaching do they go? And understanding exactly the strength of those rights is going to determine how you can go about policing those rights. Register your exclusive IP rights to provide the greatest deterrent. Registration is really public notice, and if you are providing notice, most likely 80% of the people are going to do the right thing. You're going to have 20% that don't. So you're going to at least eliminate that 80%, and then you can deal with the individual companies or persons that don't respect your intellectual property. It's going to dramatically reduce the budget that you need to allocate, especially litigation. Allocate your resources efficiently. Not all nails need to be hammered. So the idea, again, going back to our threat assessment and scoring it, and really understanding your return on investment, scoring it, and then coming up with a cumulative summary of that. That's going to really be an important step because we do work on limited budgets. And again, use the tactics. There's some common tactics, but there's a lot of tactics I think that lend themselves particularly to particular IP rights. We talked about how cease and desist letters are probably most effective when it comes to trademarks, not very effective when it comes to patents. We talked about some of the administrative proceedings that can be used, and we talked about how patents actually are a wonderful way of figuring out what's out there is really reviewing patent filings that are being done by your competitors and reviewing products on their website. So there are certain tactics that are going to be more efficient than others depending on those IP rights. At this time, I think we have completed the conclusion of our presentation and invite all of you to participate in a question and answer session for the next 5 minutes.